Please be seated, everyone. We are now going to hear the case of State versus Cungtion. Before we get started, I want to make sure that I can hear remotely Mr. Bender. Are you there, Mr. Bender?
Yes, I am. Can you hear me?
Yes, thank you very much. Somehow get our attention if you have any issues, but looks like it's going well. Thank you.
Thank you.
Mr. Rogers and Ms. Adams will approach the podium when it's your turn. Okay, thank you. All right, we will start with Mr. Bender.
May it please the court. Madam Chief Justice, Mr. Rogers, we are here today on the issue of Indian sovereignty. Whether a court has criminal jurisdiction over offenses committed in Indian country is governed by a complex patchwork of federal, state, and tribal law that often depends on whether the defendant or the victim is an Indian. And that is clearly what is involved in this case with Mr. Cungtion. I believe a brief overview of what laws were in place at the time that Mr. Cungtion's deferred judgment was revoked is important for this court to make a determination on whether or not Tama County District Court had jurisdiction. In 1948, Congress conferred criminal jurisdiction over offenses committed on the Saxon Fox Indian Reservation in the state of Iowa. It's very important that the 1948 law also reserved to the federal government that they have jurisdictions over offenses committed by or against Indians or Indian reservations. This law stayed in place for over 70 years until 2018 when Congress repealed the law. It was on December 11, 2018 when former President Trump signed into law, which basically was a one paragraph bill passed by Congress, which says that the 1948 law is repealed. The effect of the repeal was that it stripped Iowa of jurisdiction over crimes committed on the Meskwaki settlement that involved Indians as perpetrators or victims, but left intact Iowa's jurisdiction over crimes committed on the Meskwaki settlement that didn't involve Indians. But I think it's also important to note that 2 years prior, that the Iowa legislature also passed a criminal jurisdiction law regarding the Meskwaki settlement. And that is found at Iowa Code 1.15a, which pretty much states it's mandatory in Cungtion's view that the state of Iowa tenders to the United States any and all criminal jurisdiction which the state of Iowa has over criminal offenses committed by or against Indians on the Saxon Fox Indian settlement in Tama.
Counsel, what is your response to the tribe's assertion in their brief that because Iowa was not a Public Law 280 state, that there was no statutory basis for the state of Iowa to go through that retrocession process?
I think it's a clear intent that the state it goes back to the 1948 law. The state was given the jurisdiction with respect to the criminal offenses on the reservation. At the same time, it also talked about that the federal government retained it. Yes, on 2016, it basically told the federal government it need to have jurisdiction over the offenses on their settlement. I know the state and with respect to retrocession, they make an argument that because it was not until the 2018 law, the 2016 law is not applicable, but we argue that the Iowa legislature passed this law. It was on the books at the time that Mr. Cungtion was charged. In 2002 years later, Congress repealed the law. And at the time the deferred judgment was revoked in 2020, the district court did not have jurisdiction at that time to revoke the deferred judgment.
Isn't the
And-
real issue, though, that the defendant pled guilty before the 2018 Act? And then, yes, I understand that the motion or the 2020 action was taken by the district court after the fact, but before the fact of the PL 115-301 passing, the crime had already occurred, and the defendant had pled guilty. Isn't that correct?
That is correct. It was, I believe, the trial information, and he pled guilty on the same day of November 30th, 2018. And the law was actually passed in the House in November 1st, 2017. The Senate passed it November 27th of 18, but former President Trump didn't sign into law December 11th to 2018. So you are correct.
Mr. Bender, with respect to federal jurisdiction over crimes and the settlement, what changed after President Trump signed this act into law?
Well, the biggest change is that Meskwaki has exclusive jurisdiction over criminal prosecutions when it involves the Indian as either the perpetrator or the victim.
No, what changed with respect to the federal government's jurisdiction?
The federal government jurisdiction, well, in our view, didn't change at all because they retained.
If that's correct, under Code 115, 1.15a, it says that jurisdiction over Iowa cases shall cease when the United States assumes and accepts jurisdiction from the state of Iowa. And I guess if nothing changed at the federal level, maybe the statute is in effect a nullity. It assumes something that's just not true because there was no transfer of jurisdiction from the state to the federal government. What is your response to that?
If I understand your question correctly, what the federal government had in place from the 1948 law that was repealed was the fact that the Iowa courts was given jurisdiction, the primary jurisdiction, but the federal government retained jurisdiction if it wanted to. What the 2016 law under 115A says was, no, we want federal jurisdiction on all the cases. And that's what 2018 Congress under 115-301 basically effectuates the 115A, which is fine. The federal government will, the Meskwaki settlement will retain their jurisdiction.
Well,
and
Counsel,
that's what.
I'm sorry, Counsel. What about the General Savings Clause, Iowa Code Section 4.13? What effect does that have here?
Well, I believe it's Mr. Cungtion's view that the General Savings Clause does not save this, the application of this law. When it's a jurisdictional stripping case, statute, like this is, that does not effectuate a general savings. It does not call in question the general savings. And the U.S. Supreme Court has looked at it under the federal U.S. General savings, and it says when it's a period jurisdiction is being repealed, the General Savings Clause does not save that statute.
Isn't that kind of a play on the word jurisdiction? I mean, there are two kinds of jurisdiction. There's jurisdiction of a court to hear a particular case, and that's what is generally talked about when we talk about a jurisdiction stripping statute. And then there's criminal jurisdiction, which is the authority of a sovereign to prosecute somebody. And in the latter case, I don't think that there are jurisdiction stripping cases that say that a savings statute wouldn't apply to the latter case. It seems to me that that would not be a result the legislature would generally want. I don't think the Iowa legislature or Congress would typically want a situation where the law changes and somebody who committed the crime and has already been charged under that law gets a free pass.
But see, Justice Mansfield, we're not talking here where a criminal defendant is getting a free pass. If this court states that Public Law 115301, prevents the Tama County District Court to revoke Mr. Cungtion's deferred judgment. He is still subject to federal law, either under the General Crimes Act or through the Assimilation Act of the U.S. Code. So,
but a federal court isn't going to revoke his sentence under a state law conviction.
no, but you were talking. But Justice Mansfield was saying that he will go scot-free. He will go free. Well, he wouldn't be going free because he is subject to federal jurisdiction.
Actually, I wasn't saying that. I think I was saying that he would get a free pass, which I meant a free pass from the criminal case and the crime under state law that he committed. Well, there might be some way to pursue him under federal law if the statute of limitations hasn't run and so forth. But what, it seems to me this is a very technical point you're making, and don't you have to answer the difference between criminal jurisdiction and jurisdiction of a court?
Well, we're talking about jurisdiction of a court. We're talking about whether or not the Iowa has jurisdiction. We're not talking about whether it's a civil or criminal. We're talking about the totality of whether or not an Iowa court has jurisdiction in this case, based on the repeal of that occurred in 2018 or even the 2016 Act. And what the Cungtion's brief that was written by his prior attorney before I came onto the case, they argued that those laws there prevents Iowa to have jurisdiction to revoke the deferred judgment, and that that is where the jurisdiction stripping analysis comes into play here.
Mr. Bender, so let's talk about just probationers generally and assume that you have people who could be on probation under supervision of the DCS for 5 years. What happens to those people after the federal law?
Are you talking about if they're being subject, if we have somebody in Mr. Cungtion's position here who's on probation?
Right. If your view is that the state's authority as a sovereign ceases upon enactment of the federal law, what authority does the Department of Correctional Services have to continue supervising people on probation?
Well, it would be that it's Mr. Cungtion's view is that all state jurisdiction ceases. So that includes Department of Corrections, and that he'd be subject to federal jurisdiction to the federal government at that time.
So your position is everybody on probation upon the enactment of this federal law is no longer on probation under state supervision. Is that correct?
We're talking about, I'm not talking about, because I do not know how many other criminal defendants that this is applicable to. I believe it's just it would be only via a small segment, if any, if only a very few. And under Mr. Cungtion's circumstance, he would not be subject to Iowa jurisdiction. He would be regulated to federal jurisdiction.
Let's assume the statute of limitations has run, that it's not a murder case or something, that there's just a level of an offense with let's say a 2-year statute of limitations. If the time has run, he's on probation, and the state trial information was timely filed, he was convicted or pled guilty, sentencing order was issued, placed on probation. Under your analysis, if the probation goes beyond the original, let's say the trial information was filed on the eve of the statute of limitations, so it's gone. Under your theory, even though maybe he's been extremely and incredibly unsuccessful on probation, he's done?
First of all, I believe it's, if I'm not mistaken, under the federal law, it's a 5-year statute that they have if it's not for a high-level offense.
But I'm assuming he wasn't charged federally. Are you assuming there was a federal charge too?
He is currently being detained on a federal detainer as of right now. I do not know the extent of his, because it's not in the record that is currently before this court. I do not know what, if any, of the charges are. All I do know is that there's a federal detainer on Mr. Cungtion as of right now.
Hypothetically, if he were had been sitting in prison this whole time, would the effect of the federal repeal require his release from state prison?
If he was, I just want to make sure I have your question correctly. Was he convicted and he's in prison because of a conviction?
Right. I'm exploring the parameters of your theory that the state is stripped of any authority over this gentleman.
Once he is convicted, then he is subject to the state. So if Mr. Cungtion was convicted, sent to prison, and then this repeal came about, then we would not be sitting here today,
Okay, let's assume it's a deferred judgment.
which just was.
Okay, same thing. The suggestion I gave earlier, let's assume the statute of limitations is run, this guy's on a deferred judgment. Are you saying he's done?
What we're saying is because for deferred judgment, there's been no final judgment entered in this case.
Well,
And
let's assume that there was a final judgment. He was incarcerated in prison. Could he be subject to disciplinary proceedings in prison?
yeah, because if we're talking about if he was sentenced, convicted, and then the repeal occurred, it's a totally different situation than what we have right now. What we have here is he pled guilty. He was placed on a deferred judgment for the one charge that we have in this case. He has another appeal which he encompasses other charges, but he was placed on a deferred judgment. He was placed on probation. When they went to go try to revoke the deferred judgment is when the repeal has already taken place. No final judgment, no final conviction, no prison sentence was given to Mr. Cungtion until February of 2020, when he went in and had his deferred judgment revoked, which
You may sum up.
okay. I'm sorry. I see. We
That's
do
okay,
ask that
you were
this,
getting asked some questions.
we ask that this court reverse the district court and remand this back for further proceedings. Thank you.
Thank you. State? That has a ring to it.
It's been a tough week. Thank you, and may it please the court. My name is Aaron Rogers, and I represent the state of Iowa. The repeal of criminal jurisdiction here was not retroactive. There are multiple paths that we can analyze it by. The main two are looking at the state statute as informing the federal repeal, or just looking at the federal repeal alone. I'd like to focus first on why we should look at the state statute as informing the federal repeal. And then when we look at the content of the state statute, that tells us it was not a retroactive repeal. And then I'll move on and talk about if we ignore the state statute as informing the federal repeal, that interpreting the federal statute alone with interpretive principles also reaches the same result. So the state and federal government went through a process of basically statutory retrocession. The statute doesn't apply because Iowa isn't a public law 280 state. Iowa was a predecessor to the public law 280 state, got its jurisdiction through a sole statute in 1948, and I think 3 other states got jurisdiction in a similar way, New York and Kansas and North Dakota. And then later, Public Law 280 formalized the process, and 1323 of Title 25 became the process by which a state could give this jurisdiction back. And now, I wasn't able to find that North Dakota or New York or Kansas had ever given jurisdiction back, so we might be breaking new ground here, which is why I called it a retrocession, because the preferred nomenclature isn't defined. So Iowa tendered jurisdiction back to the federal government via 1.15a, which is the first step of the retrocession process that's statutory. So the federal government and the state of Iowa, I think we're trying to find, how do we do this? How do we, how do governments as a federal system pass jurisdiction back and forth? Sure, the federal government could have just repealed it unilaterally. It has, complete, Congress has all of the power when it comes to Indian country. That wasn't reserved to the tribes, obviously. But that's not what happened here. And listening to the debate, the floor debate for the Senate file that became 1.15A, the sponsoring legislator said, well, last year we had a concurrent resolution. Iowa House and the Iowa Senate sent this resolution to the federal government saying basically the same thing. We're tendering jurisdiction to the federal government. Congress didn't act. And Iowa's representative in the Senate contacted this legislator, according to him, and said, we need more. We need the legislature and we need the governor. We need a statute. So the federal government, through its representatives, solicited Iowa's input on this repeal. So the Iowa statute should inform what the federal government repealed. And so if we're interpreting the Iowa statute.
So 1.115A is what you're suggesting is the Iowa's, their view on how this should happen, right? Okay, so if we look at that language, it says, as soon as the United States accepts and assumes, and we can talk about whether or not there's anything to accept or assume because the federal government had its own jurisdiction. But at least from their perspective, as soon as the United States accepts, all criminal jurisdiction on the part of the state of Iowa shall cease. Why does that not mean that as soon as Congress did in fact then enact the 2018 Act, why does that not indicate that the state intended for everything to stop at that moment, and so that their pending criminal proceedings wouldn't stop as well?
The language of 1.15A is broad, and it sounds like it might include retroactive jurisdiction, but the legislature isn't writing on a blank slate. 4.5 of the Iowa Code says that if a statute is not expressly retroactive, it has prospective application only. And so that is something that the legislature incorporates basically into its statutes. So we read the language, all criminal jurisdiction on the settlement shall cease prospectively, unless the legislature had said retroactively, or this does affect pending cases. If there's no language of retroactivity, we presume that it's prospective only.
Has some appeal if we're looking just at, what the Iowa legislature meant, which is what you kind of do when you look at statutes. But so Congress, when they passed the 2018 Act, expressly looked at this statute. It seems like when you look at the legislative history. So can we assume that Congress was also looking at all the other statutes, Iowa statutes, when it's looking at the prospective and the savings provisions of Iowa statute, or should we just look at the 1.15A language if we're looking at what Congress was thinking?
The U.S. Congress is getting a statute from the state of Iowa. Looking at it practically, it has lawyers who are advising the representatives, and that's probably why the concurrent resolution got sent back. So I think that they would have interpreted the state statute. They would have looked at it, and the federal government, if it's unclear, if there's a possibility that it's retroactive, the federal government isn't going to just repeal it if Iowa doesn't want it to act retroactively. That would be not deferential, not an act of comedy. I think principles of federalism in the background would say that the federal government isn't going to repeal jurisdiction that Iowa isn't tendering, especially when the federal government specifically solicited Iowa's input.
Language of the statute, it says as soon as all criminal jurisdiction shall cease. That seems pretty broad.
But it also, in addition to 4.5, the tender by Iowa affected a repeal, and Iowa has a savings clause, like the federal government has a savings clause, which says, is Iowa Code 4.13, says that
The Iowa statute didn't repeal anything, so I'm not as convinced by the Iowa savings provision. The prospect of 4.5 is a better one. But can you switch then to the federal savings provision? Because my concern there is that all the cases that I've seen related to the savings provision or application of Iowa USC, or of 1 USC Section 9, applies to very specific legislation where that legislation is the one that creates the penalty or the liability, and that's what is repealed. So I'm looking for a case where that's been applied more broadly, because in this case, what's being repealed is the state's jurisdiction, criminal jurisdiction, which doesn't in and of itself create a penalty. It just incorporates, it just says that the state can enforce all of its criminal laws against certain people in certain places. So I'd like to hear what case you think interprets Section 9 broader than just applying to the very specific statute.
I didn't come across a case that addressed a repeal like this, where the federal government is repealing the state's jurisdiction. The federal government's grant of jurisdiction in 1948 gave the state authority to impose every punishment, every penalty, every liability under its criminal laws. So it is a revocation of all of them, but it is also a revocation of the specific ones. And that might be the best that I have there, besides going to the specific language of the federal savings clause that says proper prosecutions for penalties, forfeitures, and liabilities are to be treated in force unless Congress explicitly says that they are retroactively affected.
What is the state's position with respect to cases where liability, criminal liability has accrued prior to the repeal, but the case is not prosecuted until afterward? So, for example, you have a murder committed in 2016, but nobody's charged until 2022. What is the state's position with respect to that initiation of that criminal action?
Jurisdiction, as Justice Mansfield alluded to, is akin to Iowa's territorial jurisdiction. It focuses on the criminal act, and that is when jurisdiction accrues. So our position would be that criminal jurisdiction includes acts that were done before the repeal, and Iowa would have the authority under its territorial jurisdiction, under its criminal jurisdiction, to prosecute those acts despite the repeal.
Mr. Rogers, the state seems to make, the tribe has made what struck me as a pretty cogent argument that this statute, that this 1.15A is just kind of a signal or a gesture, and therefore, because there's nothing for the United States to accept and assume from the state of Iowa, because the United States already had that. You seem to be fighting that argument that would win you the case. Help me understand.
I want to clear up, my position is that either argument wins me the case, the state side or the federal side. But I do think that the federal government did cede the state of Iowa some of its jurisdiction, in that the federal government's jurisdiction was exclusive before 1948, and its exclusivity was done between 1948 and 2018. So Iowa ceded back its criminal jurisdiction, so that, I don't know exactly what the federal government is accepting back, but it's regaining its exclusive jurisdiction over the settlement. So I think that is what is going back to the federal government under Iowa's tender in 1.15A. And
But if Iowa did nothing and the federal government decided it just wanted to terminate Iowa's jurisdiction over tribes in the settlement, over crimes in the settlement, it could have done that. I mean, Iowa's participation in this was merely a matter of comedy, I guess, but it wasn't necessary in any legal sense.
Not even have been, had any legal effect, and I would say that, but the federal government is including Iowa in the process in its repeal. So I think that what Iowa tendered informs what the federal government repealed. So if it had any legal effect, if Iowa had done it incorrectly in 1.15a, if it would have messed up the works, I don't think so. But my argument is that it matters because the federal government included Iowa in the process and solicited its input, and Iowa gave its input in 1.15a. So I would say that if we give credence to the Iowa tender or not, if we look at the federal repeal on its own, the Iowa interpretive principles in Chapter 4 show that Iowa did not tender its jurisdiction retroactively. It did not intend this to apply to pending cases. If we look at the federal repeal on its own, federal interpretive principles show us that the federal government did not intend to repeal jurisdiction retroactively. It did not intend to affect this pending case. Defendant's case was pending. His judgment was deferred. He was on probation. The repeal didn't have any effect. His case was still pending. So the district court properly revoked his deferred judgment, entered judgment, and I'd ask the court to affirm.
The amicus, is that going to be argued by Ms. Adams? Thank you.
May it please the court, I'm Ann O'Connell Adams on behalf of the United States. The United States has just a couple of points to make today. The first is that the retroactivity of the 2018 Act is governed by federal law, and we think it should be evaluated under the federal savings statute, 1 U.S.C. section 109. And under that statute, the repeal of a statute does not extinguish pending prosecutions for penalties already incurred unless Congress says otherwise. Second, we take no position on whether the state legislature did something here to get rid of state court jurisdiction over a case like this, but we don't think that state law controls the scope of the federal law. At least as an initial matter, this is a question of federal law to determine whether the 2018 Act applies retroactively. The federal
Section 1.15a of the state code inform what Congress was doing when it did repeal it, though, when it referred to it in its legislative history?
I think so. I think Congress could have done anything here. I mean, if the state would have said, we would like to give back our jurisdiction, except with respect to pending cases, we want to continue those. And if Congress had said in the 2018 Act, we hereby, repeal the 1948 Act, including jurisdiction over cases that are pending, I think the federal act would control. And
certainly the federal act does control, but when the repeal does not say one way or the other whether or not it applies to pending cases, and when Congress was expressly including Iowa in the process and refers to 1.15a, I'm just wondering if 1.15a at least informs what Congress was thinking about whether or not the repeal applied to pending cases.
So I think that under the text of the statute, Congress has to tell us if it wants the new statute to apply retroactively.
The text of Section 9?
The text of
statute.
Under the savings statute, Congress has to tell us if it wants it has to give us some kind of a.
9 applies to the repeal when all it does is repeal Iowa's criminal jurisdiction when the 1948 Act in and of itself imposes no actual penalty.
we've found, this is kind of an unusual statute, but we did find one case that we cited in our brief. It's the Masai International case from the DC Circuit, where they were talking about there was a repealed jurisdictional provision, and the DC Circuit said, well, the federal savings statute, section 109, could extend that jurisdictional provision, but only if the conduct at issue took place while the underlying criminal statute was in effect. So the language of section 109, that penalties were incurred under the statute, the DC Circuit said in that case what that means is while the statute was in effect.
Delarama, doesn't that help you as well? Because didn't that case involve, a combination of a substantive law that also had provided for jurisdiction in the district court, and then Congress repealed the whole shooting match, and Frankfurter says, no, that remains in effect, so.
I think that case comes a lot closer to, because there was both a substantive provision and a jurisdictional provision, you could say that the liabilities were incurred under the Act because they were incurred under the substantive provisions of the Act and also while the Act was in effect. And I'll
say that the substance was there, though. And so it's easy to say that the liability was incurred under that Act because that Act is the one that created the substantive law. But here we don't have the substantive law. And so that's where I was just, look, I agree. It's a unique situation, and I couldn't find any cases as well. So I was curious if you had.
The best case we found was that DC Circuit case, the Masai International case, and also just point out that the Supreme Court interprets Section 109 pretty broadly. So even if Congress just decreases the penalty for a statute, that counts as a repeal under this federal savings statute. And so we think that's the best way to do it here.
About this, you mentioned procedure versus substance. Could this be thought of as kind of direct or indirect liability under the statute? So, the savings clause says penalty or liability incurred under the statute. And in a way, all criminal liability in Iowa indirectly flows from that because you couldn't do it in the absence of the statute. Is that another way to conceptualize it?
Conceptualize it, yes. That the 1948 Act essentially flipped an on switch for all state criminal laws. It talks about conferring jurisdiction on the state of Iowa rather than its courts, and I think that's an important point to make on the jurisdictional point that Mr. Bender was making. I know the court seems to have recognized that jurisdiction in that distinction in the conversation that's taken place today, but Congress doesn't control the jurisdiction of the state courts in the way that it controls the subject matter jurisdiction of the federal courts. And in the 1948 Act, Congress was conferring jurisdiction on the state of Iowa to enforce its state criminal laws against people and on land that it otherwise wouldn't have authority to prosecute under federal Indian law. My time has expired. If the court has no further questions, we would ask that this court affirm the lower court. Thank you.
Mr. Bender?
Yes, Madam Chief Justice. I do want to clarify a couple points here. The state is trying to state that 115A is broad. That's what they argued here today. We think that 115A is pretty, it pretty much states what Iowa was intending, which is that all state jurisdictions shall cease once federal jurisdiction takes place. And we do believe that that's what occurred here. I think what needs to go back, I believe it was Madam Chief Justice who asked me the question regarding a deferred judgment in my original argument time. I think, because this is a charge that Mr. Cungtion was on a deferred judgment, I think it's very important because a trial court does not exhaust its jurisdiction until it enters a valid judgment. And the valid judgment in this case did not occur until February 2020 when his deferred judgment was revoked.
Well,
However,
Mr. Bender, what about the interpretation of all criminal jurisdiction shall cease to mean that all criminal jurisdiction for acts before repeal shall cease? Isn't that a plausible reading of the statute that eliminates a lot of the problems that have been explored by the court?
Well, I think if the legislature intended that, it would have placed that in there, but it did not do so. It wrote in there that, all criminal jurisdiction on part of the state of Iowa shall cease, once the federal jurisdiction, when the federal government assumes and accepts jurisdiction.
Well, but we often refer to criminal jurisdiction as dealing with acts. Where did the act occur? Did the act occur in Illinois or Iowa?
Sure.
And so, I'm sorry, my mic was off. I'm having trouble with the notion that there's a gap here where, because of the handoff between the state and the federal government, certain criminal sanctions are going to fall to the wayside. There's going to be windfalls for certain defendants that are in certain procedural posture. I doubt that was what was intended by either Congress or the states. I mean, it seems to me the goal of these two statutes is to have a seamless handoff, and shouldn't we try and interpret both statutes in a way to accomplish that goal? I mean, I guess that's a functional analysis of the words, but please give me your best response.
Well, I think if you look at what the U.S. Supreme Court stated in McGritt here recently, I think it talks about this judicial gap that you're talking about, and it recognized that here in this type of case, if there is a judicial gap, that is hardly foreign to this area of the law, and that's what McGritt is saying. They recognize that there could be a judicial gap, but they recognize also that when we talk about Indian sovereignty, that it's most likely will occur in this type of law.
So counsel, I think what you're saying is your cutoff point is conviction. Anything prior to that shuts off?
Because that will run there, because in this case, because Mr. Cungtion did not get convicted until the deferred judgment was revoked, that's where the cutoff is.
So let's say a party is in a trial for a month. A jury comes back at 5 o'clock, finds the defendant guilty. It's December 10th. December 11th, I think the statute goes into place. Before the court enters its judgment of conviction, that means that the defendant's trial was a nullity?
I think what we need to look at here is, I know you want me to answer the hypothetical because you're trying
and
to
add
pin
to it
down.
that the statute of limitations has run.
Based on what McGritt has stated, they will recognize that there could be a jurisdictional gap where that, and that would be expected, that there could be a possibility. And in this case, under the hypothetical that you presented, which is not what happened with Mr. Cungtion, is that, based on the repeal, is that the jurisdiction for the state of Iowa ceased once it was repealed. That's what the original attorney for Mr. Cungtion on appeal, that's their argument they made in their briefs, and that's what they're arguing here on this appeal. And I do think if you look at the sovereignty, I see my time has expired, so I'll wrap up real quick here.
Well, you can answer that hypothetical.
I do think that, based on how the argument's been presented, that it would be the argument that it would cease at the time of the repeal. And we do ask that you, after reviewing all the case and as it relates to Mr. Cungtion, we do ask that you reverse the district court in this case. Thank you.
Thank you.
And Madam Chief Justice, can I take one moment here?
Sure.
I do want to thank you for allowing me to appear remotely, and I think rest of the court also.
Thank you. The case of State versus Cungtion is hereby submitted, and we will recess for the morning and resume in the afternoon. Thank you very much, Audubon Wheelers, for coming here. It may have been not quite what you expected as far as the cases, but as you can see, there are certain issues in each case that are very interesting for us to go back and forth with questions. So our opinions will take a little while for them. What we do next is conference the case as a full court. We go back and forth. It might take a few weeks, it might take a few months, but we are on a term basis. There will be an opinion submitted that will reflect the majority of the court, and that is public record, and you will have an opportunity to review that once it is published. Court for the morning is adjourned. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.